Good afternoon, everybody, and thank you very much for joining us here today to discuss the Leahy-Smith America Invents Act. As you all know, this sweeping patent reform legislation was signed into law by President Obama on September 16, 2011. I'm Peter Pappas, Chief Communications Officer at the USPTO, and I'll be moderating our webinar today. This webinar will be the first in a series of webinars that we will be hosting with our user community in an effort to receive your feedback and input as we move forward with implementing this critical legislation. This particular session will be focused on the America Invents Act and is but one of a series of events that we will be hosting in the weeks ahead to seek public input on the implementation of this legislation. Webinars like this allow us to engage our user community directly and to have you help us devise the rules implementing this legislation. I'd now like to turn it over to Director Kappos for some brief introductory remarks, and then we'll take your questions. Director Kappos.
Okay, well, Peter, thank you very much. Happy to be getting together today. I'm in this format about the America Invents Act. As Peter mentioned, we'll be doing a number of these discussions, and even beyond. I'll make sure I've got the mic close enough here so that everyone can hear. And I'm hoping that also that this series of sessions can become more of a discussion and less of just a question and answer, because one of the things that that everyone will soon understand is that if you don't have all the answers to all the questions, we don't have all the answers to all the questions either. The legislation has a lot of give and take in it. There's lots that needs to be discussed, and we'll benefit from having robust discussion over time. We also may do some experimenting with the format of these discussions to try and foster a collaborative kind of a discussion format over time. Now, over the last 2+ years, it's really been tremendous to be able to work with the IP community on moving this agency forward, and of course now we're all going to be working together on implementing it. You know, I have a lot of meetings with CEOs and other business leaders from companies of all sizes, and of course very small companies and individual inventors, and I hear over and over again the desire to strike the right balance, to strengthen patent rights in an appropriate way, to make things easier for entrepreneurs, to drive our country's growth. And the topic of the AIA fits very well into this kind of set of discussions. So in our ongoing commitment to act on the innovative spirit that has frankly defined our nation from the beginning, we feel that the President's signature on the Leahy-Smith America Invents Act is obviously an important event for our country, and also sets in motion clearly the most significant overhaul to the patent system of its kind for many, many years for the U.S. The law has already caused some important changes for our intellectual property system, and of course many more will be coming. We're already conducting studies to examine the international protection for small businesses, international patent protection for small businesses. We're already offering accelerated examinations in a third of the time of a regular examination. We're already resourcing the USPTO to operate under the Act, to have the people and the skills that we need to in order to implement the legislation. And we're already offering inventors the patent protections that are starting to work on offering the new protections that are needed to move their business forward. Now, of course, there's still plenty to do, but the entire USPTO team is together and working on this challenge with you, the IP community, with our constituency, and we're excited about implementing this legislation in a thoughtful and constructive way. Again, in partnership with our user community. So I'm going to stop there, so there's plenty of time for questions, and as I said before, I hope more discussion than just questions as time goes on. We realize this format is somewhat limited in that regard. But please make sure to stay as a part of the conversation, to be a part of the conversation even after the webinar. And what I mean by that is to get on the USPTO's AIA microsite at uspto.gov/America Invents Act, and there you can have a discussion, you can input questions, comments, issues, and we will look at them and be as responsive as we can be. So stay part of the discussion. It's your legislation, and if you help us and work with us, we'll implement it very successfully. All right, Peter?
Thank you. Our first question comes from John McCormick and is directed to Director Kappos. Director, with more control of fees generated by the USPTO under the America Invents Act, will there be a renewed effort to open the Detroit satellite office and any other satellite offices?
Right. Well, John, that's a great question to start off with. The answer is yes. In fact, we've already started. We started immediately while the ink from the presidency was still wet on the paper. We began re-energizing our Detroit efforts. In fact, we have a team headed to Detroit today working on phases of the implementation there. We've got to now reselect a site, and we've got to do the build out, so there are a number of steps to conduct. But we are very much on it, so much so that, as I said, we're putting people out in Detroit today. Relative to other offices, we're also working on that issue. The legislation specified a set of steps that we should take, and we're taking those. We're conducting a very objective evaluation based on criterion that are mandated in the legislation, and we will go through that series of steps and make some thoughtful decisions here, very objectively over a period of time to hopefully find and initiate other satellite offices. So thanks again. Great question.
Can I add to that,
Sure.
Dave? I think that's great, but I'd like to also, in the discussion, talk about a widely disseminated workforce, not only having nodes in specific locations, but one of the frequent reasons we have for folks leaving the Patent and Trademark Office after being trained for so long is spouse relocated. And it'd be really good for our applicants and our examiners to have the ability to have examiners across the country. And I think that would be a good way to look at the ultimate office that we actually end up having.
Yeah, Bob, that's a great point. And so that's how the satellite offices dovetail with the nationwide workforce initiative, right? So for those who don't know, last December, Congress passed legislation permitting the USPTO to, I think, be the first in the government to pilot what's called a nationwide workforce. In other words, to put employees all over the country and to move away from some anachronistic sort of 19th century requirements that have forced our employees to come back, including getting on airplanes or trains or traveling long distances by car, come back to the USPTO every other week, whether they needed to or not. So we no longer have to do that. We have gone through the task force. We immediately worked on implementation, put together all the guidelines we needed, worked with our three important labor unions to get consensus. We sent those nationwide workforce materials over to, I guess it's called OPM, the Office of Personnel Management, is that right, several months ago, and we're working with them to get their approval, get everything finalized, and we intend to implement the nationwide workforce, which means we're going to have these two, cross-cutting initiatives. One is specific satellite offices opening up, and then the other one is hopefully the profusion of employees all over the country, including, the Detroit area, but all other areas. I see the two initiatives as very much working together and not just coexisting, but actually supporting one another. Having satellite offices in various parts of the country enables us to have hubs, right? Not just one hub in Washington, D.C., but hubs potentially in various different places. that can be spots where examiners can come in to conduct on-site interviews as needed, spots where the public can come in and interact with examiners who have duty hours and are answering questions, places where other processes, even appeals, for instance, can take place, where folks who, board judges, for instance, who live in areas other than Washington, D.C., have a place to come in and conduct hearings. All kinds of activities can occur at these satellite offices that'll involve employees working at the offices, but also employees who work in the geographical area, but not necessarily at the office.
There's actually a follow-up question from Andrew Turner. I think you've partially answered this, but I'll direct this to Commissioner for Patents Bob Stoll. How will the USPTO distribute work between the USPTO headquarters and the satellite offices, and how will examiners interact with their supervisors?
Well, those are excellent questions. Our initial thinking is that we will not have specific areas in each of the offices. You're going to have talent way across the board, having different expertise in different areas. So the distribution of work is going to be very interesting to determine how we actually put certain work in certain places. I would think, for example, in Detroit it may be more natural to have material science type work and mechanical engineering, recognizing that they have a hub for that, but it can't be limited to that. So it's going to actually have to relate to the work coming into the office and what needs we have here. Currently, we are very high on, for example, telecom type of applications, and we'll need that more broadly than we'll need some of the other areas. With respect to actually interfacing between the examiner and the supervisor, that is key to a successful operation. I'm very concerned about mentoring capability because it takes many years to develop a great examiner, and the sense of community. So we need to look at our IT solutions to see if we can't find better mechanisms for interacting with each other across these distances. And I think that's very important to a successful distributed workforce.
Thank you, Bob. Now let's turn to the question of how the AIA impacts small businesses. And this question will be directed to Deputy Director Terry Ray, and it comes from Liliana Cerullo. Will small inventors incur costs they have not previously had to incur because of the new first-to-file system? I am concerned that deep-pocketed companies will file first, and I want to know how this will impact the independent inventors so they are not discouraged from making filings.
Thank you very much, Peter. That's an excellent question. First of all, I should tell you that the USPTO has always reached out and done its best job possible to communicate with the small business and independent inventor community, and that is still extremely important to us right now. As a matter of fact, we co-sponsored a symposium at the Smithsonian American Art Museum last Thursday and Friday. I spoke there, Congressman Watt spoke there, very high-profile individuals in the D.C. area. The AIA Act was identified very often, and as a matter of fact, I think that most of the members in the audience appreciated the fact that the AIA actually is going to make their job easier and actually will not cost them any more money. There are a lot of things in the Act that I will go through very quickly just to highlight for you right now, but I think that's a bit of a myth to say it's going to cost more. What I think most independent inventors will find is that they will have the same certainty that the first to file brings everybody, and that certainty will make their patents and their applications more valuable and easier to license. I think the cost actually could be a bit less. I will go into later on a little bit about the micro entity, the potential of not just paying 50% PTO fees as a small entity, but also the potential for paying a 75% reduction in fees for a micro entity. I also would like to say that we have a number of, studies that Congress has instructed us to follow because they were very cognizant about small businesses and small inventors the entire time the AIA Act was under discussion. And one of those proposals is a international patent protection for small businesses. This is a global economy, a global playing field, and it's just as important for independent inventors and small businesses to file internationally. So last Thursday, We had sort of a fact-finding discussion here at the USPTO. We had a number of people testify and provide their ideas as to how perhaps we could assist small businesses and independent inventors to finance their foreign filing. Actually, the period for written comments does not expire until November 8th. So those of you who would like to provide comments and perhaps come up with creative financing mechanisms could do so as soon as possible. Also, other programs that Congress wanted us to follow that would help the small business and independent inventor community would be like our pro bono study. Right now we are collaborating with independent groups in Minneapolis that we hope to duplicate throughout the country, where if you're of a lower income and you don't have the means to actually pay for someone to draft a patent application, it could actually be done pro bono. We're trying to expand those right now. Also, we were instructed to establish and maintain a patent ombudsman program to provide support and services to small business concerns and independent inventors. We also, 1 year from enactment, we have to provide to Congress a report on the effects on small businesses when we switched to the first-to-file system. So Congress wants to make sure that your interests are being followed and identified during this entire process. We do not want to disadvantage small businesses or independent inventors. And I already went through the possibility of additional reductions. Does anybody else have anything to add?
There's actually a follow-up question on that, so let me pose that to you now, Deputy Director. Mike Drummond would like to know, when will the 75% micro-entity discount take effect? And there's a follow-up, will that discount apply to institutions of higher learning located outside of the United States? So let's start with the 75% micro-entity discount.
Okay, thank you very much, Peter. I'm sure everybody realizes that this is a very important provision in the America Invents Act, and the 75% fee reduction in PTO fees to micro-entities will actually probably not go into effect for approximately 12 to 18 months, because we have to have our entire fee-setting provisions completed at that time. And of course, as you know, our fee-setting and our rulemaking process takes a little while to actually, I guess, complete. So unfortunately, we cannot start the 75% micro-entity fees at this time. With respect to the second part of your question, Peter, whether universities located outside the United States can participate in the microentity plan, unfortunately they cannot. The way the legislation was written, it was based on 20 USC 1001A, which defined an institution of higher education as an educational institution in any state of the United States. So unfortunately, our colleagues outside the United States, universities outside the United States, cannot benefit from that 75% reduction in fees.
Thank you very much for that extremely comprehensive response. We now have a question that will be directed to General Counsel Bernie Knight on one of the topics that always comes up, which is the question of fee diversion. Bernie, on the matter of congressional fundings, this question is from Zachary Pape. He would like us to clarify what congressional powers Congress still retains to appropriate funds to the USPTO, and under the AIA, will there be any restriction on Congress's ability to divert funds as it has in several years in the past?
All right. Zachary, thank you very much for your question. I know that this is a question that many people have had. And I'm happy to say that I think we have a pretty good result in the legislation, and let me explain that to you. First of all, the legislation provides that for funds to be available to the PTO, they must be appropriated by Congress. But Section 22 of the Act also provides that if the PTO collects more fees in any year than are appropriated, those fees go into the Patent and Trademark Reserve Fund. And those fees cannot be used for any other purpose by Congress until they're later appropriated to the agency. So Section 22 of the Act establishes a fund that prevents our fees from being diverted for other purposes by Congress. In addition, we've seen a couple of advanced copies of Congress's Appropriations Acts for 2012. And each of those advanced versions provide that the PTO will be appropriated all of its funds. So Congress actually, in the advanced copies of our appropriations language that I've seen, Congress is actually being true to their word here and appropriating to us all of our fees. Finally, I would add that there are 2 fees that are automatically appropriated to the PTO in the American Invents Act, and those 2 fees are our prioritized examination fees, which you know are $4,800, and also the 15% surcharge is automatically appropriated to the agency without any further appropriation by Congress.
Hey, Peter, just before we go on, just a couple of other comments I would add to that. One, thanks for the answer, Bernie. I would also add that we recognize that by no means did the legislation completely address the possibility of future diversion of agency collections. The language that was proposed by Senator Coburn in the Senate version of legislation, I think, fairly said would have done that. The legislation that we wound up with does not guarantee that we will get to use all of our fees in the future. As Bernie said, so far so good with the current year appropriation. There are a number of other issues that come up, both in the long run, whether future appropriations will be enough to let the agency use the money that the applicants are paying in, but also there's the more immediate issue of continuing resolutions, the system that's used to fund government operations during periods when there isn't a budget, which is what we're in right now. We're in what's called a CR period. And so far, so good in the CR period for us. We're being permitted to move forward with implementing the legislation. But of course, there are no guarantees going forward. And if these CRs continue, like they did last year, for instance, well into the new year, the USPTO could face some pretty unfortunate circumstances, such as we did last year. So situation, as Bernie said, is clearly better. It's significantly better, but by no means have we reached any kind of a panacea relative to funding.
I would also like to add that I think that the fee-paying community needs to be very vigilant if they're interested in this issue to make sure that all the funds they are paying to have their applications examined are in fact appropriated to the Patent and Trademark Office. I think vigilance is key.
Very good point. Moving on now to the question of the grace period. This question is from our friend Gene Quinn and is directed to Director Kappos. It's got several parts, so I will read them. The first part is, how does the U.S.
Gene usually has
yes,
several parts.
exactly. He's very good at that. How does the USPTO interpret Section 102B? And then here's the subparts. Some people say that if someone else independently invents and publishes after the first to publish, but before the inventor actually files, this second publication cannot be prior art against the inventor who first published. Is that true?
Well, Gene and team, this area, grace period, is an example of where there's lots in the legislation that is going to be clarified over time. U.S. legislation provides a blueprint, doesn't try to provide, the equivalent of specifications or line drawings or mechanical drawings for any particular area of the law. So it leaves a lot of issues to be developed over time, including some issues surrounding the grace period. In general, I would say that our new grace period is going to be is going to tend to promote disclosure. It's going to tend to promote openness. It's going to protect an inventor who discloses an invention from having another come in and get a patent to it for the 1 year period following the disclosure. The new grace period will also have the benefit of dovetailing very well with the requirements for creating prior art. And what I mean by that is that in cases where in the past there was a mismatch, a particular event that could potentially implicate prior art but not potentially a grace period, now we've got a situation where in some cases you won't create a prior art event in the first place, so you won't need the grace period. But if you do create a prior art event, you will be sure to have access to the grace period. And so I'm going to leave that as an answer to these kinds of questions generally, without, frankly, devolving into a minutia-based discussion. We can do that over time using the AIA microsite and discussions at the staff level around the agency. Okay, thanks, Peter.
Thank you very much, Dave. This next question relates to third-party submissions, and I will direct it to General Counsel Bernie Knight. It comes from James Leon Kane. How do the new provisions in the AIA, which allow third parties to submit prior art references, differ from current reexamination process, which also allows third parties to submit and challenge newly issued patents?
Do you want to take that one?
Dave or Bob? This was a question originally directed to James.
Hi, Peter, maybe I can just touch base
Sure.
with that. I apologize. James Smith, the Chief Judge of the Board of Patent Appeals and Interferences, couldn't be with us today, so this actually falls within the scope of reexamination, which is his world. Third-party prior art submissions are sort of our way of thinking of a means of crowdsourcing. The statute's a little bit more complex, but within 6 months after a patent application has been published, members of the PTO community can submit references to the U.S. Patent and Trademark Office to actually assist our examiners in making sure that they've identified all of the best prior art possible. Now, a reexamination is different. A reexamination occurs after a patent has already been granted. And, for instance, someone might become aware of references that were not discussed during the regular patent prosecution, and it's a way for us to reconsider our work product and perhaps for the applicant to amend their claims in view of that prior art.
Thank you very much.
We are currently allowed to submit third-party references during the prosecution of the application under 37 CFR 1.99, I believe. And they're more capable of doing it under this new system. The time period is critical. Take a look at the statute, but we need to make sure that we're getting those submissions in as early as possible in order to effect the examination of the application. And it's simply the submission of the actual information, and a Federal Register notice will be going out shortly to actually define the requirements for that submission.
Thank you, Bob. Bob, this question I think is a good one for you, and it relates to design patents. The questioner is Donald Rampt, and he would like to know if a design patent application which has been patented in another country can now be filed in the U.S. within 1 year of its foreign filing, as opposed to 6 months prior, as was the case under 102D as modified by 172.
My quick answer would be no, that section of 172 was not changed. They are permitted to use the grace period of 1 year, but I believe 172 still requires a filing within 6 months of the actual priority document. And I also would like to point out that a provisional cannot serve as a basis for priority for design applications in the United States.
Thank you, Bob. I think this question will be for Terry Ray. Terry, Philip Gamble would like a little clarification on Section 33A about patenting. Can you explain a bit about that section for him?
I tell you what, Bernie, do you want to do a first cut at that?
That was organisms, right?
Organisms, yes.
Right. Sure, Terry, I'd be happy to. That's a great question as well. Section 33 of the AIA really just codifies our long-standing practice at the PTO that a claim encompassing a human being is not patentable. And one of the things that I know all of you know is that we have been patenting, for example, isolated and purified DNA since the 1980s. So this Section 33 of the AIA is not going to prevent the PTO from continuing to patent medical diagnostics, such as methods for treating or diagnosing patients. And I know, Terry, you're an expert in the biotech industry, so let me turn it over to you for your comments.
Yeah, to those of you out there who do work in this particular area, I must say that pretty much it's the status quo is being maintained. Congress just codified our general practice and our general method of examination. So it should not change things at all, methods of treatment, methods of diagnosis. The statutory types of claims that you're used to drafting are still effective and valid, even post-AIA. Thank you.
And I would just add for those practitioners in the office, if you're interested, this policy is written in Section 2105 of the MPEP.
Okay. A follow-up question, which again I think you partially answered, but this is on the definition of human organism. Is human organism limited to human beings and human embryos, or are there circumstances in which it encompasses methods of treating or diagnosing humans and human cells?
Peter, I think I've already answered that. And I said that, we've been, issuing patents, for example, on isolated and purified DNA since the 1980s. So we're still going to be issuing patents on medical diagnostics, methods for treating and diagnosing patients. That's not prohibited by Section 33.
Especially recombinant DNA, cells, cell types. The general practice, the status quo continues today. Thank you.
All right. This question just came in over the internet, so I'll see who wants to take this one. This relates to a secret sale. What is the USPTO's position regarding a secret sale under the now amended Section 102? And this comes from Brett North in Mater, Louisiana.
I'll take it, and I'll kind of give Dave's earlier answer. I actually believe this is something that the courts are going to have to determine. Sale is stated within the specification. There's nothing in there that says secret sale. My guess is that the determinations are going to be very fact-based as to whether or not something like that would bar a patent. And I kind of go with Dave on this, that we need to wait and see what the courts determine on this particular subject matter.
Okay. This question is for Bernie Knight. We know that the AIA requires the USPTO to conduct a series of rulemakings as well as studies. And can you tell us a little bit more about how you expect that process to work?
Sure, Peter, I'd be happy to. As all of you know, we're going to be issuing many regulations in order to implement the various provisions of the AIA. And when we issue regulations, a lot of people are not experts in federal rulemaking, so let me give a little bit of background. First of all, there's three types of rules, basically. There are substantive rules, and then there are procedural and interpretive rules. With respect to substantive rules, that is a rule that will affect someone's property rights or rights to a patent. We are required by the Administrative Procedure Act to issue a notice of proposed rulemaking. We publish that for approximately 60 days. You will have an opportunity to send in comments with respect to our notice of proposed rulemaking and the changes that we plan to implement or the new procedures we plan to implement. And then we are required to take your comments into account before we go out with the final rule. And if you look at our final rules, you'll see that we actually do analyze all of the comments, and we discuss why we accepted the comment or why we couldn't accept the comment. Now, another type of rulemaking that we do is a procedural rule or a mere interpretive rule. And that's a rule that merely provides for procedures for how you're going to interact with the office. For example, do you have to file electronically? Can you file in paper? What kind of paper? Any procedural aspect like that is a procedural rule. An interpretive rule is just a rule that mimics the statute. And with respect to interpretive and procedural rules, we do not have to go out with a notice of proposed rulemaking and seek public comment. Sometimes we do that voluntarily where we think public comment would be helpful and where we also have the time to do it, because that's very time consuming. But with respect to procedural and interpretive rules, many times we'll go out with a final rule. And I'll give you an example of that. When the Act was passed, we went out with a final rule immediately to implement the Track 1 prioritized examination fee of $4,800. And in that case, we could do it because we were merely parroting what Congress provided for in the AIA, and we needed to implement it immediately so that you could all take advantage of our new prioritized examination procedure.
Very good. Now, one follow-up question for Director Kappos that comes in over the internet. Director Kappos, you've had a very busy 2 years and seem to be off to a running start on the implementation of patent reform legislation. What are your goals for year 3 of your administration?
Well, thanks for the question. Our goals now are simply, number one, to implement this legislation effectively, and that's why I come back to the point of needing to collaborate with the IP community. You know, you've seen from the questions asked today that folks are concerned, have very detailed issues that they want to address. So do we. We need to work through these questions together, the ones that don't have ready answers. So we're very interested to know about what members of the IP community think are the right policy-based approaches to take to things, to issues like the grace period and secret prior art, those kinds of issues. We're looking to set a good example and to let good policy and good practice be our guide. So that would be the first part of the answer, Peter, is that we're going to work on and focus on successfully implementing this legislation. I think it's fair to say, as the questioner mentioned, that we are off to a good start. We've had good interaction with the IP community starting way back before the legislation was actually even signed back in July, and we're continuing to move forward I think quite well. As many of you know, we've got an implementation coordinator, Janet Gongola, here in the Undersecretary's office. We're putting tremendous energy. A number of us, including myself, have already spent more than an hour today alone working on AIA, and not counting this this webinar. And we'll spend a lot more time before the day is out and continuing this week. And this is just an example of a typical week dealing with AIA implementation. The other thing I'd say is that, you know, in addition to implementing the legislation, we've still got to, in many cases, keep the trains running on time, and in many other cases, get the trains to run on time. So we're cognizant that we got to keep working off these big backlogs that we got to deal with. You know, Bob Stoll and the patents folks here have made some, I think it's fair to say, pretty substantial progress on the patents backlog, bringing it down to about 669,000 applications the end of last financial year. But we've got a long ways to go. We still want to bring it all the way down to somewhere around 350,000 applications. So we've got a few more 100,000 to whittle away, but we're clearly making some progress there. Continuing to make progress is a high priority, and that means resources and hiring examiners and training, and continuing with the efficiency improvements that have gotten us to where we are will continue to be priorities. Everything from continuing to invest in the Common Patent Classification project that we're working on with the EPO, which will be transformative to our efficiency, everything to continuing to work with our unions on good management practices and award-based practices for our examiners that incent fast and efficient and high-quality prosecution. We will continue to work on all of those things. I mentioned before, so I'll mention again here, we're hopefully very close to coming out with another new practice improvement that we refer to colloquially as 117 practice that will enable applicants to avoid having to go into RCEs in many cases when they don't want to, saving money and keeping cases on examiners' fast docket. So we're going to keep implementing processes and procedures, and we're going to keep running the plays that we've been running that have enabled us to make some substantial progress, and we're going to keep taking those backlogs down. Same time, you know, as you all know now, we have a big backlog in the board of appeals that we need to deal with. And our chief board judge, James Smith, is working hard to bring the people in and put new processes in place. Terry Ray and I here and James were exchanging emails here over the weekend as recently as yesterday evening regarding all of the things James is working on. Very, very positive work. And with his team and with more resources for the board, we're going to keep working on getting on top of that backlog. You know, on the trademark side, much better shape. We're on top of the backlogs there and operating very much in a steady state mode. But on the trademark side, we're going to keep focusing on very high quality, on leading the world in development of good trademark policy, dealing with some of the new issues that are coming up in the trademark area to retain the vigor of the use-based registration system, and ensuring that as the world of brands becomes more global, that brands are respected. The U.S. is in there leading and ensuring the vibrancy of the trademark system. So, you know, again, complicated answer to a short question, but it's like any, you know, big set of challenges. There are a lot of things you do to try and deal with them. We do have AIA to implement. We are intent on getting that right and timely, and I'm happy to say so far we're doing pretty well. But by the same token, we are not going to take our eye off the ball on things like backlogs and continuing with the process and efficiency improvements, the re-engineering work that has proven to be very helpful to the agency so far. But we need to keep our eye on that and keep going with it all, and we plan to do exactly that.
I'd like to add, I mean, and that sounds like a lot, but there's even more going on. I mean, we are moving to a fully end-to-end electronic process. That's a huge initiative that we're undertaking under Dave's auspices. We're also re-engaging and reinvigorating our harmonization discussions internationally, which is another very important aspect of our improvement. And one of the not much talked about but very important aspects that I think happening in patents is the early and frequent communication with the user community. I think that this initiative where we now have examiners calling applicant before sending out a first office action is a huge culture change, and I think we're going to continue to work on improving the culture at the Patent and Trademark Office and the collaboration with our user community.
And I think I would be remiss if I didn't point out right now that Dave envisions expanding the agency as necessary so we could better serve our user community. So the usajobs.gov website is something that I would become familiar with for a few of you out there. On the Board of Patent Appeals and Interferences anticipates hiring over 100, I don't know the exact number, new judges this year. And Bob Stoll, how many new examiners are you envisioning hiring?
The model that we have set right now is for 1,500 examiners, and that anticipates full access to all of our fees and will allow us to possibly get down to as low as 10-month pendency by the end of 2014. So we are really improving and working at the Patent and Trademark Office to get this backlog down.
Yeah, good additional points, both Terry and Bob. And Terry, thanks for pointing out the USA Jobs point, which is really important to us in terms of our recruitment effort. So back to you, Peter.
Thank you. This question is from Chris Durkee. The USPTO already has a green tech acceleration program, and the America Invents Act provides or allows that prioritized examination is limited to technologies deemed, quote, important to the national economy or national competitiveness. Has the USPTO defined these technologies, or can you comment on how you intend to determine what those technologies are? We'll start with General Counsel Knight and then go to Commissioner Stoll.
All right, unless you'd prefer to go first, Bob.
Absolutely not.
Okay, good. Well, let me say, first of all, Chris, the American Invents Act does not limit the prioritized examination program to technologies that are important to the American economy or American competitiveness. The limitation in the Act is basically that we cannot in any fiscal year take more than 10,000 applications into the prioritized examination program. And that limitation stays in place until the director issues regulations under the program. And as I stated earlier, the director can issue new procedural regulations or interpretive regulations under this Track 1, what we call internally Track 1, but in the Act is called the Prioritized Examination Program. What I was what I was trying to say is that the director can issue new procedural or interpretive rules from time to time, changing some of the requirements for prioritized examination, and you may see that in the future with respect to the program. Also, prioritized examination currently does provide a 50% discount for small entities, and as Terry stated previously, there's no micro-entity discount until we establish new fees pursuant to Section 10 of the Act.
Bob.
Well, Dave likes me running lots of projects and lots of pilots, and I think we've really looked at some of these, and we've got some interesting ideas that we're about to discuss. I think Green Tech has been an extremely successful project. It may be time now to roll that into our Track 1 and start experimenting with other ideas. So we're about to actually discuss ideas about accelerating applications that are stated or proven to be job creators, looking at a new category to pilot that and see if that would be an area. Maybe also looking at what we call the humanitarian type of patent acceleration. So there are many more ideas. Look in the next couple of months, and I think you're going to see new pilots for new types of accelerated programs.
Stay tuned for that. Okay, this question comes from Brian Szymanski, and I believe Director Kappos and Bob touched on it a bit. But the question is, how long will it take to drive down pendency and the backlog to what are acceptable levels, and what are the ideal levels of backlog and pendency?
Well, just to add to what we've said, so this is something everyone can look at our dashboard for more information on this and keep up on a very regular basis. Our dashboard is on the uspto.gov website. Now, to be specific, our view, and would love to hear if anyone disagrees. I've asked whether anyone disagrees. It seems like 100 times in various fora, and have never had anyone yet say they disagree. But our understanding at this point is that the ideal time to first action is, as Bob said, 10 months, which means that you get it not the Goldilocks syndrome, not too soon and not too late, just in time to be able to decide whether you want to go for overseas filings, but not so early that that prior art, which otherwise will be available to us, is not yet available to us. So that's what leads to 10 months to first action as an ideal time to first action. And our view is that the ideal time to final action, final disposition, hopefully issuance of a patent or final rejection, is about 20 months. And the reason we have come to that view is that 20 months ensures that in the vast majority of cases, you will get your 18-month lead time before your application issues and therefore becomes published. You won't have a large numbers of patents issuing at, say, 15 or 16 months and causing pre-publication. But by the same token, you won't have large numbers issuing much after 18 months, and that's why we establish the 20 months as the guide. Now, how long will it take us to reach that goal? It depends on funding. I'll tell you quite honestly, we had plans when I started at the agency now over 2 years ago. We would have been much further along the way had we received access to the fees that are paid into the USPTO. However, we have not received access to those fees. We had a record amount of over $208 million diverted last financial year, and not that much, but a large amount diverted the previous financial year. And in each case, that manifests itself in the agency not being able to do the things that we like to do, not being able to hire more examiners, not being able to move forward with our information technology-related projects, and on and on and on. And so there are choices and consequences, and when the choice is made not to provide the fees that are being paid to the agency to do the work they're being paid for, it should come as no surprise that that work then doesn't get done in a timely fashion. So if we do get continued funding at this point, so going forward, if we're able to get funding, as Bob mentioned, we're targeting 2014, the end of the year 2014, at the point when we would reach the 10 months first action target. And of course, that depends on not only on funding, but on some estimates regarding patent application growth rate, which I believe we're currently estimating will continue to grow in somewhere around the 5 to 6% range. Requires those estimates playing their way out with, reasonably accurately. If growth in patent application filings were to suddenly soar, we would be in a different world, obviously, and if something else were to happen, we would have to deal with that. But I'll let Bob comment a little more.
Just if you've got a real compelling interest to get your application out the door much quicker, don't forget about our track one, keeping it to limited number of claims and paying your $4,800 if you're a large entity and $2,400 if you're a small entity, can get your application to final action or allowance within 1 year. So don't forget there are mechanisms for moving extremely important applications quickly through the system now. And Director Kappos is thinking a lot about lots of different instruments so applicants can make the timing of their own application what they prefer.
Okay. This is a question relating to the backlog. The backlog was over 750,000 when Director Kappos took office, and it now seems to be under 670,000. What is the ideal backlog number, and is the USPTO trying to drive the backlog down to zero, or is there some other higher level that represents the ideal backlog?
So I'll help with that one. As I mentioned already, the ideal number, which is approximately at this point 350,000 applications, you can imagine is the result of a rather complex calculus. Like all of you, when you do work, you come into the office in the morning and you have work sitting there on your desk or in your inbox or whatever to do. If you had to run your operations at your companies or your law firm in a way where every morning when thousands or in many cases hundreds of thousands of employees come into their work, they have absolutely nothing on their desk to do. That's what's called zero inventory. You would have a big problem managing your businesses. That's why every business has a certain thought about workflow, how many dockets an attorney carries, those kinds of things. You want to have a continuous workflow with some new work and some in-process work, et cetera, on everyone's desk, whether real or virtual desk, at any one point in time. And it's the very same thing at the USPTO. And so for various of our art areas, we have an ideal number of dockets that examiners should carry. Obviously, art areas where processing goes faster have more dockets that you want examiners to carry. In art areas where more time is required on each case, it would be fewer dockets. Then you've got the issue that comes into play of the seniority of the examiner. More senior examiners process cases more quickly and therefore need more dockets in their workflow. More junior examiners process work somewhat more slowly and additionally have different balance to their workload because they tend to be dealing with mostly new cases and therefore they don't have a huge amended docket. They've got a mostly new docket. So if you go through and run the numbers for what we currently have about 7,000 or so examiners, run all those numbers, right now what it comes down to is about 350,000 applications in inventory at any one point in time, which would mean somewhere in the neighborhood of 50 to 70 or so dockets sitting on the desk of each examiner at any one point in time. Some of them new, some of them in amended state, some of them final, some of them after final, all the different categories. And that produces a good functional workflow. And by the way, that's the same number of dockets that gets you to 10 months to first action and 20 months to final action. So it's at the point where what we call the backlog, or what you would start to call the inventory, the working inventory, it's at the point where the working inventory hits that ideal level that you also get the ideal processing time. So the good news is we don't have to go to zero. We've gone from 750 to, say, 670. So we've taken about, many tens of thousands of applications off. We got several 100,000 more applications, but we're on our way. We're clearly making some progress there.
Thank you, Dave. I think we've got time for two more questions. I think this one will be a brief one, and I'll turn to Bernie Knight for this one. This is from Courtney Brickerhoff. How many applications have been filed to date under Track 1?
Well, let me turn that over to Bob since it comes into his organization. Do you have a...
I have a rough, I think there were about 53 applications filed between September 26 and October 1. Since then, there have probably been 300 applications filed starting the new 10,000 as of October 1, somewhere in that time.
So a nice uptick. That's great. And I think this last question will be directed to Director Kappos. Director, there's a lot of talk and emphasis on reducing the backlog, but we tend not to hear quite as much about patent quality. How important is patent quality, and what is the USPTO doing to ensure that you issue only high-quality patents?
Well, I'll tell you what, I talk about patent quality a lot. In fact, if left to my own devices, you will hear me talk about that a lot more than I do the backlog. You might want to take a look at copies of some of our speeches. I'll say Terry's speeches, my own, Bob's. We post those on our website, and you can see extensive coverage of quality and the importance of quality. You know, the reason I took this job in the first place, and I hope I can speak for Terry and Bob and Bernie and Peter also, is the reason that we are in government service is to try and produce value for our country. We all get that driving down the backlog by sacrificing quality is not producing value for our country. The most important thing we do at this agency, more important than bring the backlog down, more important than anything else we work on, is to develop quality processes, quality systems, and therefore produce quality in our work output. We put a tremendous focus on that, and that's why some of the first things we started working on when our administration started, including writing for the first time 112 guidelines for the agency. That's all about quality. They included writing the extensive 101 guidelines. That's all about quality. They included commissioning a task force which held 2 public meetings, 2 rounds of extensive input from the IP community over the first year of our administration that led to our creating 5 new quality metrics that makes the USPTO the world's leader, I believe, among all patent granting authorities in having the most extensive, objective, and complete set of quality metrics, bar none, of any patent granting authority. We have been measuring according to those for a full year now. We're now in the process of transitioning our dashboard reporting over to now our 5 plus original 2, total of 7 quality metrics, and you should watch those as we report them on our dashboard so that everybody can see together if the agency is making progress relative to quality or not, if we're getting better relative to quality or if we're not getting better. The last thing I'll mention in that regard is that, like many practitioners, you know, we know here that quality is in some important ways a function of the amount of time that people have to spend on their work. I mean, you all know if you're given a certain number of hours to prepare a patent application, you can get to a certain level of quality, all other things being equal. If you're given some additional time, you can usually produce a higher quality application, up, of course, to some point of diminishing returns. Well, we're nowhere near that point of diminishing returns at the USPTO. We all knew that when we started as an administration. So one of the first things we did, which runs, I will readily admit, and I told the Secretary of Commerce this at the time and defended this decision, one of the very first things we did was to give examiners across the board more time to examine patent applications, right? And so when you're trying to drive a backlog down, you would say if the most important thing to you was to drive that backlog down, the last thing in the world you would do would be to give people more time to do their jobs. But, and this is why I say we're quite serious about quality here, the most important thing is quality, and therefore we went and gave examiners more time, and we felt that if we did it in the right way and encouraged that time to be used on early resolution of issues, it would actually manifest itself both in an improvement in quality and down the road in an improvement in pendency. And indeed, our theory, our calculus, and our management and leadership judgment was borne out. We did see immediate across-the-board improvements in quality And you can look at those and see those on our dashboard also. And over time, as has been discussed already in this conference call, we did see we are seeing now improvements in the backlog. So great question. Quality is where all of the action is in terms of producing the patent system that we want for our country. We're on that, and we're going to continue on it.
Okay. Thank you very much, Dave. I think we've unfortunately run out of time, even though the questions keep coming in, so I think we're going to have to wrap up. I'd like to thank all of you for submitting your questions ahead of time and also through our web portal live today. We will do this again in the very near future. I want to thank Commissioner Bob Stoll, Deputy Director Ray, Director Kappos, and General Counsel Knight for their time, and thank you very much for engaging in this dialogue with us. Thank you.